Change of scenery. We give Justice Nyman his work. Can you pass that to him?
Housekeeping.
Change of players.
Thank you. Thank you. As reconstituted, Justice Blake is now sitting in instead of Justice Hand. Our next and last case is 23P120, Gordon Andrews versus the Zoning Board of Appeals of Halifax. Mr. Brodsky.
Members of the panel, may it please the court, my name is Adam Brodsky, and I represent the defendant appellant, the party trust. Amanda Monte and Edward Johnson, two of the trustees, are in the courtroom this afternoon, or I should say this morning, excuse me. While the party trust is grateful for the trial court's flexibility in allowing the party trust to pursue a cure for its alleged permitting deficiencies, the trial court erred in two respects. First, the trial court erred by not dismissing Mr. Andrews' building permit and enforcement appeal in the first matter, which is styled Andrews 1, which was brought more than 1 year after the planning board granted site plan approval for the multifamily development known as Amanda's Estate, and the grant of the special permit approving the same project by the Zoning Board of Appeals, and was untimely under Chapter 40A, Section 17.
And what's your best authority for that proposition? And by authority, I mean precedent, not a land court case. Is it the Bonfatti case? That sort of states a general proposition. What's your best case?
The statute is strictly construed, Your Honor, to require the filing of an appeal within the statutory period. I'm happy to provide you with an additional citation. You're referring to my reference to the Coolus matter, which was a land court trial decision which had recently been issued and dealt more specifically with an instance of a building permit appeal. In that case, the allegation was that the relief granted was wrong, and that's why it was relevant at the time to bring that to the court's attention. But I'm happy to get back to you with that. I think there's ample authority for the strict construction.
I understand the general proposition, and I know what the statute says. I'm looking for a little bit more in-depth analysis.
Thank you, Your Honor. And I'll speak to that momentarily, or I can jump right into that issue. I just wanted to point out that the second error that the party trust believes the trial court engaged in the consolidated cases was the rejection of the Zoning Board of Appeals' reasonable interpretation of the multifamily development bylaw. The multifamily bylaw does not require the subdivision of the property to locate each building on an individual lot. And the trial court's decision, we respectfully say, undermines multifamily development in Halifax. But let me give you more analysis.
I certainly can't speak for the rest of the panel. I'm actually more interested in issue 2 than issue 1, but it's your time to use as you see fit.
Your Honor, I'm happy then to speak to issue number 2. Thank you. Your Honor, you'll note that neither the site plan approval nor the special permit granted, and this was originally in 2014 and 2015, expressly required subdivision control approval of this multifamily development. And in fact, the record will show that the planning board in 2014 simply told the party trust to just show lot lines on the plan and did not require subdivision approval. This project was approved at or around the same time that the Halifax Trails project was approved, another multifamily development project permitted in 2014, which its plans also showed lots, but there was no requirement for subdivision approval. Those permits for Halifax Trail lapsed, and the record will show that Halifax Trails was re-permitted in 2016. And in fact, at that time, the question of subdivision was raised. And Chairman Andrews Mr. Andrews' father, who's the former chairman of the planning board, stated that Halifax Trails was not a subdivision, and referring to the Record of Appeal, Volume 3, pages 34 and 38, quote, "In order for you to make it under subdivision control, then it wipes out multifamily." The multifamily bylaw also does not state that an applicant must obtain subdivision approval. Section 167(7)(d)(2)(a), which is referred to as the trial court's subsection A, only requires that a multifamily development complex, and there's no definition in the bylaw of multifamily development complex, shall locate each building on an individual lot.
So it's interesting. Mr. Andrews says in his brief at page 40, that your argument relies upon a mischaracterization of the decision, that says there's no statement that it requires subdivision. He said that the judge merely stated that subsection A means what it says. Each building must be on an individual lot with continuous frontage. So why is he incorrect?
Your Honor, because the bylaw does not require subdivision control. The Board of Appeals, which interpreted the bylaw, didn't require subdivision control. That's a reasonable interpretation.
But he says that the judge never said that it requires a subdivision.
I don't think that's accurate, that we're required to divide these lots. The only viable way of dividing
So what
these
you're
lots.
saying is that by interpreting subsection A in that manner, by definition, it requires subdivision. Is that correct?
Yes, Your Honor. There's no other way to divide property in the Commonwealth other than using the subdivision control law, either an approval not required plan or a definitive subdivision. So we read, Party Trust understands that Justice Vey was requiring that we go through subdivision control to create these lots. And that's what we think is the judicial error here.
So what then is meant by must be on an individual lot which shall have continuous frontage on a public or private way? What exactly does that mean?
Simply what both the planning board and the zoning board required, that we show a plan that showed each of these buildings on a lot. And we suggested to the trial court that the
You show a plan
reasoning-
that on an individual lot, but it doesn't ultimately need to be built. Each one does not ultimately need to be built on an individual lot? Is
doesn't
that
need to
the
be
argument?
divided. Again, Your Honor, you may recall that there's a density requirement within the multifamily bylaw, Section 167(12)(a)(1), which requires that the number of units cannot exceed the number of acres. And so there has to be some mechanism by which you would demonstrate this to the boards. In a typical multifamily development bylaw, it's something called a yield plan, where you actually show the planning board, what can be done and whether it meets the density requirement. The trial court rejected that argument by us. We respectfully suggest that how else can you demonstrate this by showing to the planning board and the zoning board of appeals that in fact you've located each building on a lot and meet the density requirement. Again, Your Honor,
Just to be clear, and I apologize if this is not a great question, but you're not making the argument that subsection A and 167(12)(a)(1) are irreconcilable. You're making the argument that they must be read in conjunction with one another in this context. Is that
yes, Your Honor,
correct?
that's correct.
And that absent doing that in this context, it's a nonsensical result.
Yes, Your Honor.
Okay.
And I'd say may lead to an absurd result here, as I've argued in the brief. Again, the trial court created a new definition for multifamily development complex without reference to town meeting minutes or any legislative history as to what the town intended by this bylaw. And it defined a multifamily development complex to mean 2 or more buildings on one lot, and distinguishes it from a multifamily development which should have only 1 building on a lot. And as I argued to the trial court, it begs the question of whether the town, in enacting a multifamily bylaw, intended to promote multifamily development with 1 large building on a lot, understanding that for a multifamily development, each of these lots has to be not less than 10 acres, and suggests that a single large multifamily building on at least 10 acres in Halifax, which is a rural community, is contrary to the intention of the bylaw, would violate the design guidelines for multifamily development, because that's clearly not in character of the neighborhood or the town and is not desired. And we argued unsuccessfully to the trial court that the interpretation of the bylaw articulated by the trial court to require subdivision to create subdivision lots for multifamily development doesn't make common sense. This project is located within the town's agricultural residential zoning district, and two-family and duplex dwellings are allowed by special permit. A developer, rather than pursue a multifamily development with its additional requirements, you have to have a lot of not less than 10 acres. You have specific dimensional requirements for multifamily development. You have design guidelines. A developer faced with the decision would simply divide the property into conforming lots and pursue two-family or duplex dwellings by special permit, and that the trial court's decision and interpretation effectually wipes out multifamily development in Halifax, as I think was suggested by Chairman Andrews in the planning board in 2016 for Halifax Trails. So I'm happy to answer any other questions of the panel, but we would...
I'm going to ask Mr. Andrews the same question. So my understanding is that the judge left this at the end of the day, not only rendering a decision, but citing the Chambers case, basically said, look, you don't have to tear this down at this time. And that was, I think, in August of 2022. Is that where we're currently still at right now? I don't want to go outside the record, but you can answer that question.
Yes, Your Honor, because we need a decision on the interpretation of the bylaw. Our fear is, again, without understanding what the bylaws required of us, that simply filing an application for
a special permit for some sort of different purpose, you might go through all of those machinations and then come back to where you are now.
Correct, Your Honor, and as you know from reviewing the record, that we've been doing this for some time. So we need really guidance from the appeals court as to what we're required to do. Otherwise, we're going to be in a doom cycle trying to complete this project.
So I'm curious, with that said, why you think you're entitled to fees?
Your Honor, perhaps you got a sense of how this case went, all of the various claims that were asserted, some of which were...
Absolutely, but you're saying, look, we need to understand what the law says. How is that his fault? If this is a genuine dispute about what this bylaw means, I don't see where anybody's entitled to fees. Now, I haven't heard the other side, I haven't talked to my co-panelists, but it was odd to get to the end of your brief and see a request for fees.
Your Honor, our position was that this appeal, the first appeal of the building permits and enforcement more than 1 year after these approvals was
So on the first issue.
Time barred, and that unfortunately we've now spent the last so many years trying to resolve this.
Okay. Thank you.
Thank you, Your Honor.
Mr. Andrews.
Good morning, and may it please the court. Your Honors, thank you for allowing me the time to present to you. I'm sorry for the jeans. I had a mishap this morning. I have rehearsed what I was going to say multiple times to try to limit the number of details to raise at oral argument, but it becomes overwhelming. These cases, now consolidated before you, come down to conflicts of interest and special interest. During this time, I have served the town of Halifax faithfully as a member and chairman of the Finance Committee, Halifax Elementary School Committee, the Board of Selectmen, as well as just a member on the Silver Lake School Committee. I have watched time and again the party trust receive special treatment and interpretation of the bylaws from the former building inspector, Robert Piccarelli, and zoning board members, including Mr. Keziah Nezarella, along with former selectman Tom Milius, who is Mr. Piccarelli's longtime business partner. This relationship was not publicly disclosed in writing until 2019. My reputation has been damaged. I've been defamed. My character has been constantly questioned. The trust case is claiming that I should have appealed the special permit in 2015, but the Zoning Board of Appeals during its hearing process didn't have this special interpretation of the bylaw. The requirements of multifamily housing during the special permit approval process, they applied a uniform and equal interpretation not only to Halifax Trails, but to 340 Montponset Street, which was owned by Mr. Milius and Mr. Piccarelli, and Amanda Estates. Had this special interpretation been applied during the hearing process, I would have appealed the special permit at that time. The subdivision requirement was well known, and it's seen in the July 16, 2014 Seelig memo. To confirm this point, the party trust submitted another petition, number 850, to the Zoning Board of Appeals in August of 2016, and it sought relief from the very condition of 167-7D2A, as they hadn't created the lots which were required under their special permit. Again, to prove that point, Mr. Piccarelli applied for relief from the multifamily development on 340 Montponset Street. They filed, Mr. Piccarelli and Mr. Milius filed petitions 802 and 808, in which they requested a variance from the condition that each building be on a separate lot. When Mr. Piccarelli first sought his multifamily development petition, it was in petition 790. The zoning board went to the former town administrator, who was brought in, and gave a determination after talking with land use attorney Richard Huxham, that they did not have enough frontage to subdivide that lot, and they would need relief from that very requirement.
Let me interrupt you. In your brief at page 40, I just want to make sure I'm understanding this correctly. You state that the trust's argument relies upon the mischaracterization that the court's decision requires subdivision. You then state the court held no such thing, and then you go to Justice Vay's interpretation that each building, that A means what it says. Each building in a multifamily development complex must be on an individual lot with continuous frontage. Would you agree with what Attorney Brodsky said, that by definition that means to develop that land, it requires subdivision?
For their land, yes, but not the bylaw itself. Because if they had frontage on the street, or if they had a different design where they had at least 150 feet of frontage for a buildable lot, like all the other lots in town that's required for building, that they would have been able to build one building with 12 units on there.
And that'd be all the other multifamily lots as well?
Yep. So the misrepresentation, Your Honors, is the fact that this is a special interpretation for the party trust.
I understand. In your presentation, which is somewhat helpful, but please understand, we've read the briefs, we've read the record extensively, so if you have any legal concerns or legal issues to express to us, that would be preferable than going through the facts, which, again, we're very familiar with. But again, it is your time to use as you see fit, of course.
So I would ask that the court review the August 23rd, 20 decision with respect to the definition of lot by the planning board. As the planning board is a creation of state legislation under the case Del Duca versus the town administrator of Methuen, 368 Mass. 112, 1975, the legislature has taken the entire subject of establishment, powers, duties of local, regional, and state planning boards in hand, and thereby has precluded any local action which would impair the operation and affect the statutes in the field. The term lot is defined by legislation in Chapter 40, Section 81L. The land court should have determined that legislature had already defined the term lot for the planning board, and it should have used that interpretation in its decision, which would have furthered the interpretation of the bylaws and would match with what longtime land use attorney Richard Huxham's opinion matched. I would like to point out to the court that the town and the ZBA have not filed any briefs upon this appeal, and they are not here today at oral argument because they have already admitted, as the decision August 23rd, 2022 in both cases, the ZBA asserts that any interpretation of the bylaw herein is directly related to Amanda Estates and is not, I'm sorry I said this word incorrectly, prejudicial for future different projects. I would like to request the court find that the ZBA and trust knowingly and willfully misrepresented to land court the facts which have created the situation that is here before you. I would ask the court to overturn summary judgment on the decision on 167.10A and 10B. If the court reviews 167.10B, you will find that the relief that's granted is only for the number of dwelling units on the lot. It doesn't wipe away all the other requirements of the land. If it did, then all permits for a two-family would wipe away any requirements in the table of dimensions, because that special permit granted is the same for multifamily as it would be for two-family. So it would be a misrepresentation of what the ZBA has required for all special permits under that. I've spent 7 years of my life on this subject, trying to point out to the court that there have been multiple financial implications by officers of the town where they have acted on their own behalf without making any proper disclosures. I would like to point out to the court that Mr. Milius and Mr. Piccarelli had an agreement with Mr. Johnson's son, Joshua Pratty, to take a lot that they had that was unbuildable, that was worth $800. He applied for a building permit and received the building permit, and then Mr. Milius and Mr. Piccarelli sold that lot shortly thereafter for $130,000. Mr. Milius also acted as a member of the Board of Selectmen when the Planning Board asked to have access to legal counsel to review what the Zoning Board had done. He denied that. I had asked that Mr. Piccarelli recuse himself, where he had a conflict of interest. He refused to.
We're well aware of
Okay.
the allegations of conflict of interest by both parties, and we're also well aware of the judge's findings where he made them in his decision, where he did describe such issues.
I would just request any further relief that could be granted from this court. And, are there any other questions?
No, seeing none. Thank you. Thank you both.
Thank you. Rest on
We'll
the
take it
brief.
under advisement.
Thank you.
With that, we'll close this session. I'd like to thank my colleagues, our law clerks, the clerk's office, our court officers, and our excellent timekeeper, and we will stand in recess.